We're going to have to come up with answers that set politics aside.
Hey, this is Clement G from Tennessee. I'm here representing Nashville Peacemakers, Mothers Over Murder, Straight Talk, Bulletproof. They don't hear us.
They don't hear us.
Man, Black father, a son, an uncle, a nephew, a cousin. They don't hear us.
They don't listen. They don't hear us. They not listening.
They don't hear us.
And we're gonna bring you some stuff that's gonna make you feel better. They don't hear us.
I keep telling them, but they ain't listening, bro.
Hello, my name is Amana Sera. I'm from Port-au-Prince, Haiti, and they don't hear us. Yo pas nous. That's it.
They don't hear us!
Get together, stop killing.
Well, hello there, and how are you today? We are here with They Don't Hear Us. My name is Sheryl Huff, and I am the president of Middle Tennessee National Action Network. And we are here to be blessed with a special guest, and she's gonna talk with you all, and her name is?
Ashley Brown. I am Ashley Brown, a criminal defense attorney here in Nashville and the surrounding counties. I represent both adults and juveniles who have criminal charges in those counties and surrounding areas. I also handle some landlord-tenant matters, as well as small claims civil matters, and some municipal court violations that people may receive in various counties.
Okay, well, that's good to know. So we have a large listening audience, and we also have a complaint line that we have a lot of people calling about different complaints about things that's happening with them. And something you just mentioned about landlord-tenant complaints. So can you just tell us a little bit about that and how that go and the process, the procedures, or what you do on that?
Yeah, so in the state of Tennessee, there's what's called the Universal Residential Landlord-Tenant Act, and it provides a legal outline of what tenants' rights are as well as what landlords' rights are. And so oftentimes I see scenarios in which maybe someone's landlord is overcharged. There are limitations on what a deposit fee can be. There are various issues such as increase in rent in the middle of a lease term. There are various instances I've seen where people are, doing things that are just not in compliance with the Universal Residential Landlord-Tenant Act. And a lot of people who rent think that there are only protections for landlords, but there are actual protections for tenants as well.
Mm-hmm. So I know when the pandemic happened, a lot of renters was saying, well, we don't have to pay our rent because they told us we don't have to pay them, and the landlord couldn't come after them. But after the pandemic was over and now they're going back to resume their process and stuff, a lot of people have been evicted, and they were saying that because they hadn't paid their rent going forward, and now that they were raising the prices, it was like, okay, we could raise the price, so we want to get them out and do. How legal is that? Is that something that they can do, or the person can fight that?
So there are instances in which someone can fight those charges or those allegations in which they've been wrongfully evicted. During the pandemic, there was a lot of federal funding placed in the hands of landlords to ensure that, they could remain in business, as well as people weren't houseless due to a pandemic that all of us were surprised by and had no idea was come and put us in that predicament. For the most part, landlords, after the pandemic funding ran out, they had the right to increase their rent. Of course, it can't be astronomical, but in certain situations, astronomical for one person is $50, another person is $100. Right. And so there aren't very many protections in place that limit what a landlord can charge unless it's, federal housing, some type of government assistance, then those programs, of course, are still in place. But if you were renting from a typical landlord in, say, downtown Nashville or downtown Clarksville, there really weren't very many protections that could prevent a landlord from increasing the price of the rent. And so if once the mandate ended, you owed rent, there were some landlords would work with tenants, but they didn't legally have to work with the tenant and allow them to remain there for the previous price or for, free. And so I hope that answered the question.
Oh, yeah.
Okay.
So you also said that you work on criminal cases.
Yeah.
So can you tell us some of the, what criminal laws that you covered, or so the people will know?
Yeah, so criminal defense is probably 85–90% of my practice at my firm. So what that means is if someone's charged with drugs or domestic violence cases or something like disorderly conduct theft, I handle those type of cases. Children, juvenile kids can be charged with domestic assault or things of that nature. I also represent juvenile, mainly working with their parents in the initial stages, but eventually talking with that child. And so I am covering those types of cases in Davidson County and surrounding areas. For the most part, what I do is go into court and make sure that no one's pleading to something they didn't do, and also making sure the state meets the probable cause burden in general sessions, and also the proof beyond reasonable doubt in criminal court. So that means I'm always fighting for my clients. I'm never gonna put them in a situation where they feel like they need to plead and there's no proof, or they didn't, do what's been alleged.
So because we have a lot of the juveniles now that's getting in trouble, breaking in cars, taking guns, that they claim that this is what's happening. We just did a segment on knowing what your rights are. And so to remain silent, is that better when the client have no conversation with anyone, then that it helps you better to work on that case, or?
Absolutely. So what I see a lot is police officers approach people and they just immediately begin. So say someone's driving down the street and they're saying, oh, that car is stolen. They pull you over, you get out of the vehicle. What the police should do is read you your Miranda rights, because any statements you make at that point can be used to incriminate you or put you in a position in which you're serving time, or you're on probation. Just the conviction is on your record. And so oftentimes I tell people it's just best to remain silent. Even if you don't have an attorney, tell the police, I'd like to implement my right to remain silent. Or you could simply say, I'm in the process of hiring an attorney. You really don't have to say all that. You just have that constitutional right to remain silent. And I've never seen, I've not seen a situation where someone began to blurt out things about whatever they're being charged with that was to their benefit. I have not seen that scenario. And so I just don't see how it benefits anyone to begin to speak. And you have a right to remain silent, so utilize that right, because the police will make their case off you simply blurting out things, and they don't even have to investigate the case. You've told them everything they need to know.
Right. So what got you interested and want to work in the criminal law?
Yeah, so actually I will say I went to the University of Mississippi for law school. I'm from Mississippi. And I was a part of what we had there was the Mississippi Innocence Project, and I'm sure you guys have heard of the Innocence Project. And at that time I was assigned a client who had served like 20 years in parchment, like pretty much he was going to be there until he died. And we had the opportunity to hop on that case. So each semester, a set of students would work on whoever had been assigned to the Innocence Project clinic. And that was a moment in which I was able to see that so many people are just wrongfully placed in prison for life. And this guy was in prison for shoe print evidence. And apparently in the 70s, there were tons of cases in which a Mississippi prosecutor had placed several people in jail based on bite mark evidence and shoe prints. And this was one of those scenarios. And there was a lot of case law out there that just later proved that this guy had convicted several people, like hundreds of people, based on bite mark and footprint evidence. And at that point, I knew, like, okay, this is the trajectory I want to go with my legal career. Initially, I thought I would just want to do juvenile, but then after meeting with him, as the semester progressed, I said, oh no, I think I want to do both, because there are just so many people, especially people who look like us, who are wrongfully convicted and sitting in jail their entire lives. And to this day, he's still in jail, I think they reduced it, sent him back to the trial court, and so he's not in parchment, which is in Mississippi where they hold you until you die. He's now at a county jail, but can you imagine, that's the majority of your life. Even when you get out, there's no amount of money that can give you back what you've lost wrongfully. And so from that point on, I knew this is the area of law I wanted to practice in. Wow.
So we were just doing a piece where a young man was charged of murder, and with him, he had he was on the death penalty, and he served 23 years on death row. And now they finally, they knew that because the person that actually did it confessed to it and all of that, but they still held him. But now they finally let him out. And I wanted to know, when a person is found guilty and they're put in jail, then once they get out, then what is their revenue? What can they do because they was wrongly convicted and spent all of this time in jail?
And most of the time they file a civil lawsuit against, the state or the city, more than likely the state, to, ask for a certain amount of money. We hear about these huge payments, $2 million, $1 million, but no amount of money, in my opinion, will ever, account for you sitting through prison for a day, let alone 20, 10, 15 years. And so what the process is like, you then file a civil lawsuit against the city, the state, and they repay you, and your attorneys showing them basically the value of your life and what you've lost. And so oftentimes if someone goes into jail at a young age, it's hard to calculate what type of, it's like a civil lawsuit. If you get hurt on the job, they'll calculate your expected earnings. And so to a certain extent, they're treating people that look like us like property to determine, oh, at 18, this person had, maybe they had several convictions on their record. They're basing the value of what you would have been worth based on, things like that. And it's just not fair because people can turn their lives around.
And another one, they have a lot of cases when a juvenile or someone does something, and then they start using their record against them, but the record ain't the one that killed them. That person or that police or someone else killed them, but that's the first thing that they do. They start reading off their record. And why do they do that? Is that?
I mean, it's racism. It's a way to validate that life, that basically, in my opinion, it's a way to validate the wrongful killing of someone's life and to say, oh, that person, this is who they are. And so they're trying to make us believe, hey, that person isn't valuable because he or she may have, made some mistakes or probably maybe even wrongfully charged with something or overcharged with a crime. And also, I think it's unfair because we all know your juvenile record is sealed information. And so to bring that forth when someone's wrongfully killed is, it's a slap in the face to say, oh, this person does, in a roundabout way to say that they deserved it to a certain extent. And so that, to me, it's rooted in racism and,
it's bad.
Yeah, it's problematic. That's very upsetting, so.
Yeah, that's really bad. So with our juveniles and the trouble that they're in and they're pinning stuff on them, or some of them have done this, but I was hearing one lady called us in and said that her son was shot and killed by a Caucasian youth. But they're trying to convince her that this child, because now your child is gone, so we're not gonna hang this, but how do we stop him from going into adult? Can you tell me what's the difference from a juvenile serving juvenile time or being bound over to an adult? What's the difference with that?
And so sometimes if you are convicted at the age of 17 and then while you're awaiting trial or a hearing, because at the juvenile level, it could be a transfer hearing, meaning they transfer the case from juvenile court into general sessions or criminal court, adult courtrooms, because that age transfer occurs while you're held in custody. And I believe that's what you're asking me. And so what they'll do is if someone's 17 and then by the time they're convicted or by the time the case is adjudicated, if they're 18, then they could potentially, they would pretty much charge them as an adult because it wasn't resolved until they were an adult. And then the state of Tennessee, there was recent case law that several people were on life without parole, but then they implemented a new law around that age. If you were 16 at the time, then there was a group of attorneys who went back and reverse that. And I can't think of the case law, so I don't want to misstate it.
Right.
But there were a group of attorneys who took on several cases and were
Mm-hmm.
able to appeal those matters. And so those persons were then eligible for parole, although they had committed a crime at the age of 16. And I don't know the case law, so I don't want to
Right.
misquote it.
Yeah. So if that child was 16 when they committed a crime, and it's up to the juvenile judge whether he's going to bound it over to adult court, what will be the reason for that judge to say, okay, we're going to keep it in juvenile, but because he's 16 and by the time this case go through, he'll be 18, so he's going to be charged just as a juvenile, so he'll never face any time in jail. Is that
Now, juveniles are detained. I
Okay.
mean, they're not in an adult jail, but
Right.
they are detained in their own facility. So just because you're convicted as a juvenile does not mean you won't be imprisoned to a certain extent. There are facilities where they hold juveniles. And so I do want to clear that up.
Yeah.
But it's really not up to the judges based on the type of crime committed, and it's also based on the age in which the case closes on whether or not you're serving
age.
adult time or juvenile time, where you will serve your time. If it's something like murder or homicide, those charges, of course, are taken more severely, and you're more than likely handled in adult criminal court.
Okay. So I think that we need to do a whole lot of know your rights out here to make sure that our children and they know what their rights are, because now with we have all of these police officers in the schools, and the kids, they'll come and say, well, you did this or didn't you do this, and they don't know whether to talk or not to talk. Can you tell us a little bit about what they need to
Absolutely.
do?
And honestly, I think a lot of adults need to know this, especially young adults, because I have
Yes.
cases in which the police intimidate people. That's what
Yes.
they do. And so if they come to you and say, hey, can I search your car? You have the right to say no. Now, they can later go get a search warrant, and then they may have met the probable cause standard to get the search warrant. But there are oftentimes people are, frightened, they're afraid, it's dark outside, and they simply just let the police ask them questions. They may say, hey, do you have anything illegal in the car? At that point you can say, hey, I'd like to utilize my right to remain silent. And they may go get a search warrant for the car, and if they find probable cause, then they can search it. But I think it's important for people to know that, as I indicated earlier, you do have the right to remain silent. Although you may find yourself in a situation where the police are maybe yelling at you or asking you questions before you even get out of the car.
Right.
They may start to ask you questions. If you answer those questions and it's an admission of guilt or anything that they can use to incriminate you, you can find yourself with a warrant just based on you speaking. And so I do think it's really important for the public school system or even churches to start implementing programs on knowing your rights, so that we as a community know how to protect ourselves. Because oftentimes we find ourselves in like hostile environments, and maybe you are in a situation where maybe something's going on, but that's their burden. Let the police do their job.
Exactly.
That's what I tell everyone. Let the police do their job.
Right.
Yeah.
I know I heard before one attorney was saying if they get out the car and say, well, I smell alcohol on you, and I need you to take this sobriety, what is it?
The blow into the breathalyzer.
Yeah, and I need you to do that, or I need you to walk a line, and you tell them, no, I'm not going to do it. And then your attorney is better to handle the case, because they don't have no amount or know what happened when you, the alcohol that you had on them, because you didn't take the test, so they can't prove that.
Yeah,
how
and
much
then
you
they
had.
can then charge you with what's called implied consent. So basically, if you fail to administer the testing that they're asking you for, you would have the DUI and potentially the implied consent. But it is easier to, handle those type of cases, your attorney, because, there's just not a lot of evidence at that point. So you do have that right. It's up to you, yes.
Okay, and is it any other law that you work with?
Yeah, so I do handle some municipal code violations, meaning like if you find yourself in a situation in which the city is coming after you for code violations, maybe like an aggressive dog bite or failure to clean your yard and keep it up to code standards, or certain fences and height requirements, keeping cars that are parked on the grass, they might write you a code violation. I do handle those matters, and those are environmental court violations. So also sometimes they now have this new entertainment district downtown, and so they're writing violations and sending those code violations to environmental court if you're downtown and parked in the wrong area, if you're displaying yourself as a taxi and they're saying, no, you're not a true taxi. So I do handle those cases as well.
Oh, okay, that's good to know.
Yeah.
We just was working with a gentleman. He's like 89 years old, and he'd like to build stuff, and so he have all of this wood and material and all in his backyard and Kohl's. He felt Kohl's was like really coming after him, and they already was like, it's in East Nashville, and they already want to get the property
Absolutely.
and asking these people for do you want to sell and anything. Then all of a sudden, here come Kohl's coming over there and saying you have to remove this and remove that. What rights do elderly people have, because this is what they do? Do they have to move all that stuff, or?
And so there are zoning restrictions. So
Right.
every part of the county, especially in Davidson County now, with the land being so much sought after,
Right.
I see this a lot with older people in North Nashville because it's close to downtown.
Right.
And then some people have been able to remain in East Nashville, where that community has changed, already just totally.
Right.
What I want people to know is you do have rights. There's what's called municipal code law. And so I would advise you reach out and speak to an attorney, me or someone else, whoever you're comfortable with, to ensure that whatever code they wrote that you're in violation of, you're actually violating it.
Right.
And so, for instance, if there is wood buildup, there aren't any code provisions that prevent wood buildup. Now, if it's infringing on your neighbor, I would have to know the specifics of that
Right.
incident. And so that's why it's important for people to call and get advice. Sometimes you just may need an answer. Maybe you
Right.
don't need representation in court, and that's fine, But call an attorney and speak about your specific instance, because things vary based on where you live in the county.
Right.
Certain residential restrictions, certain communities have HOAs, some communities don't.
Right.
And then there's the code that overrides everything.
Right,
So it varies person to person.
Okay.
But if to me a wood pile up, I would need to know more details, because that doesn't sound like
it was more than just wood. It was his
Okay.
tools and his saws, and I mean, he had a lot of stuff. Then they were saying that the buildings that he had back there with all the stuff in there didn't get a permit for it.
Okay.
And so those kind of things. So we're working on all of that, because I made sure they had the Kohl's people, they had the council member, everybody came out just to
Oh,
discuss
yeah,
and
and that
see
is
what's going.
too.
So I had them all to come out just to make sure that what they were saying was actually the truth. So, but that's good to know, because I have a lot of those cases that come in, and our elderly people,
Absolutely suffer.
that's how they take their houses from them, and then they walk around carrying bags, living under the bridge now. So we have to do more of workshops and everything just to make sure people know what their rights are. So this is what this
Absolutely.
is for.
And
Yeah.
oftentimes older people will become frustrated and think, oh,
Yes.
should I just sell my property? They don't want me here anyway. I'm the
Yep.
last person in my neighborhood
Yep.
who looks like me, especially if it's like an elderly person of color.
Yep.
I've seen them use it with vicious dogs. Hey,
Yes.
this dog
Did
is
someone.
vicious, and she's the only person in the neighborhood left who looks like this and has this
Yes.
pit bull, and it's just discriminatory practices. But there are protections in place through the code for those type of situations.
Oh, okay, okay. Well, just tell us more, whatever you want us to know more about what you do out here.
Yeah, so I think that the most important thing right now is ensuring that whenever I go to court, people know that they do have rights when they come to court, but also that it's important to make sure you share everything that happened on your case with your attorney so that we can advocate as best as possible for you. So even if something you feel like it's bad and you don't want your attorney to know,
Right.
what we talk about is confidential.
Right.
So there's attorney-client privileged information that is not you can't share with the court. We take an ethical oath that we will keep that information confidential. And I think it's important for people to share everything with their attorney so that when we come in court, we can advocate as best as possible for you, not to share it with the DA, not to share it with the judge, not to share it with the
Right.
police officer, but just so that we can adequately prepare for court.
Right.
I also think
Expungements.
expungements.
So I know you was telling me, I think you were saying that you do expungements, help people expunge their records. Can you tell them what that means and how do you
Yes.
help them with that?
Yeah, so an expungement is applicable for certain charges and convictions in Davidson County. And there are a list of charges that are eligible for expungement, and there are lists that are not eligible. So for instance, DUI is not something that you can get expunged from your record. But a reckless driving, you could get that expunged from your record.
okay.
And what that process looks like, it varies county to county. In Davidson County, it's pretty simple to go inside to the clerk's office and let them know. Or, you know, of course, if you feel more comfortable with an attorney handling that matter for you, please reach out and get assistance. But it's a matter of keeping something off your record. So if you find yourself in a situation where a charge has been dismissed, you can immediately go, you know, and get that expunged from your record, so that if employers or if you're applying to certain school programs like graduate program, nursing program, any type of program, and you just don't want that on your record, you can absolutely go through that process of getting that removed from your criminal record, and so that you can live your life without that being held over you. And it's a pretty simple process, but again, oftentimes you need to speak with the attorney beforehand to make sure you're filling out the paperwork adequately, you're turning it in on time, because certain convictions can be expunged after a 3-year period, certain after a 5-year period, and so you want to make sure your attorney's doing that. If it's dismissed right in court, you want to make sure you immediately go down, you know, and get it expunged from your record that day.
So when a person is in court and they said that the case is dismissed, can the judge say then, well, I'm going to erase this off your record?
So it's really a clerical job. Most judges will tell you, and again, it depends on the type of charge it is, because every charge is not eligible. But if it's dismissed, you can go ahead and get it expunged.
Okay.
What will happen is most judges will tell you, hey, this is dismissed. If you want to, go to the clerk's office and let them know and get that expunged and get that process started.
Okay.
It's a clerical situation. The judge is typically just reading from a docket. They're not on a computer. If they are, they're doing legal research and making sure the case law in a hearing is adequate or a statute is applicable to a certain case. And so.
Okay, well, yeah, that's a lot of things that I hear that they said that the judge could have expunged them, and then people go years and years and years with this on their record and didn't know that once the judge said it was dismissed, they think that was it, but they still have to go and
follow
get
that next step.
Yes.
And that's why it's important, you know, your attorney will explain that to you. Most of my clients, I let them know, hey, let's go ahead and get this expunged, you know.
And a
we
lot
don't
of
have to worry about it
attorneys don't.
because if it's a week from now, we may all forget,
Right.
you know.
Yeah, so, and it's a lot of attorneys don't tell them that, so I'm glad to hear that you say you make sure you let them know once it's expunged. So, well, we are winding down, and I just want you to tell the audience where they can reach you, how, just give them information that you want them to know, how they can get in touch with you.
Absolutely.
Yes.
So I can be reached at my email address, which is Ashley, ASHLEY, at Ashley, ASHLEY, L, Brown, lawfirm.com. That's my email address. I have a website, ashleylbrownlawfirm.com as well. And I can be reached by telephone at 615-669-1025.
Okay, say it one more time so the ones that was trying to write it down can get it.
Yes, my phone number is 615-669-1025, and my email address is Ashley, ASHLEY, at Ashley, ASHLEY, middle initial L, Brown, BROWN, lawfirm.com. It is lengthy. So.
Yeah, well, I appreciate you from coming, and this is some good information that our community and people need to know.